Hi, I am attorney Chris Batan Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I will discuss concepts and principles of law in under 10 minutes.
So hello everyone, welcome to part 2 of our topic on ownership. So we start off this video lecture with a discussion on the different remedies of the owner to recover possession or ownership over the property if they are dispossessed of their property, be it personal property or real property. So let's begin the discussion. So we ended with part 1 with the enumeration of the rights or the remedies available to the owner if he or she is dispossessed. There was an enumeration in the last part of part 1 that if it's personal property and you are dispossessed or you lose possession of your property, you have the remedy of Replevin. And if it's real property, then there are also several remedies available to you. Either forcible entry, you have unlawful detainer, you have Accion Reivindicatoria, and also your Accion publiciana. So let's talk about these remedies. Now, let's talk about Replevin first, the remedy available to recover personal property. What does this mean? This means the manual delivery of personal property, which is governed by Rule 60 of the Rules of Court. Can a property in custodia legis be a proper subject of a suit for Replevin? You have Calub versus CA, which says that a property that is validly in custodia legis cannot be the subject of a Replevin suit. What is the prescription for filing such action? The action shall prescribe 4 or 8 years from the time the possession thereof is lost in accordance with Article 11.3.2. So 4 years if possession is in good faith and 8 years if possession is in bad faith. Okay. In Arabesque, you have here AIPI who filed a Replevin case against PIDEC. The Supreme Court said that yes, AIPI, you may be the owner of the boat, but PIDEC has lawfully possessed the same because AIPI failed to pay the repairing charges and lay-day fees. Here, the Supreme Court said that a writ of Replevin cannot be issued against a lawful possessor. The Supreme Court, as I've mentioned, said even if AIPI was the owner of the boat, it was unable to pay the repair charges and lay-day fees of PIDEC, and PIDEC had a lien on the boat. Now, let's start talking about the remedies of an owner in recovering real property. Okay. Now, forcible entry and unlawful detainer, these are your ejectment suits. Okay. They are instituted by a person deprived of the possession of any land or building, okay? If it is by force, intimidation, strategy rather, or stealth, or in short, fists, okay? Force, intimidation, threat, strategy, or stealth, that's fists. You call it the action, the appropriate action is forcible entry, okay? If, however, it is the possession has been unlawfully withheld after the expiration or termination of the right to hold possession by virtue of any contract express or implied, that should be express or implied, or the legal representatives or assigns of any such landlord, vendor, vendee, or other person, the appropriate action is unlawful detainer. Now, what is the difference between the two? The main difference between the two actions lies in the time when the possession became unlawful. In forcible entry, okay, the possession is illegal from the very start. That's why we said if you are dispossessed by force, intimidation, strategy, threat, or stealth, meaning from the very start, it's unlawful, the action that you must file is an action for forcible entry. If unlawful detainer, the possession was lawful from the start, and then it turned unlawful. Okay? Perhaps because the contract has already expired, or perhaps you failed to pay rentals. So from the beginning, it was lawful, but at the end, it became unlawful due to expiration or termination of the right to possess. What is the prescriptive period for filing your ejectment suits? For forcible entry, it is within 1 year from actual entry through fists. However, if it is through strategy or stealth, then entry must have been made without letting the owner know. So the 1 year should be counted from the time of discovery. Okay? So as a general rule, it is within 1 year from actual entry, but if it is through strategy or stealth, then of course you count the 1 year from discovery. Unlawful detainer is within 1 year from the date of last demand. Okay? So the period is the same, but the reckoning periods are not the same from the time when you count the 1 year. So different reckoning points rather. Where do you file? MTC. Okay. The nature of an ejectment suit is that it is summary in nature. Now, if you file an ejectment suit, is written demand necessary? It depends. If it's forcible entry, then that is not necessary. If it's unlawful detainer, then yes, written demand is necessary. Why? Because you count the 1 year from the date of last demand. What is the issue involved in an ejectment suit in your forcible entry and unlawful detainer? It is mere physical or material possession. It is not about ownership. It's about who has the better right to possess the property. Can the court pass upon the issue of ownership if the defendant raises ownership as a defense? Or otherwise stated, will the MTC lose jurisdiction over the case if there is now an allegation of ownership? Because we said the issue is merely possession and not ownership. Okay? Jurisprudence will tell you that neither claim of juridical possession nor even ownership can prevent a court from taking cognizance of the case. In ejectment suit, the issue of ownership, in case it is raised by the defendant in the pleading, may be passed provisionally upon by the court, but only for the sole purpose of settling the issue of possession de facto. In other words, your MTC does not lose jurisdiction. In fact, they can even pass upon the issue on ownership, but only provisionally, only to find out who has the better right to possess. And only when the issue of possession and ownership are so interrelated with one another that the court could not pass upon the decision on who has the better right to possess if he will not pass upon the issue on ownership. But remember, it's merely provisional. What does this mean? This means that if there is another case, and it is an Accion Reivindicatoria case, an action to recover based on ownership, and the court there decides on who has the better, or rather, who is the owner of the property, and if in that decision, the court decides contrary to the decision of the MTC, which will prevail, the decision in the court handling the Accion Reivindicatoria, or the action based on the action to recover rather based on ownership. So that's what we mean when we say that if the MTC rules upon ownership in an ejectment suit, it is merely provisional. Okay. Case of Peralta. In the case of Peralta, the complainant alleges in his complaint that the forcible entry happened in 1994, but he only filed the ejectment suit in 1996. So clearly, this is beyond the 1-year period. It was filed 2 years later. And so, the ejectment suit cannot be recognized anymore because the court no longer has jurisdiction. The 1-year prescriptive period is jurisdictional. If you have filed the case and it is beyond the 1-year period, then the forcible entry case is no longer available to you. But does that mean that you no longer have a remedy? You still have a remedy. And the remedy is Accion publiciana. In fact, Accion publiciana is actually just like an ejectment suit, but that which is filed beyond the 1-year period. Okay? And it's no longer summary in nature. Okay? Nunez versus SLTs. Here, complaint for forcible entry was filed December 2003 due to an ocular inspection that was made on October 2003, revealing that there were illegal occupants there. The truth was, the occupants were already there and entered the property through stealth in 1999. And because it was through stealth, the owners did not know about it. They only knew about it when they had an ocular inspection in 2003. And in October 2003, and they filed it December 2003. Did they file it within the prescriptive period? The Supreme Court said yes. Since entry was done through stealth, the 1-year period is counted from discovery. The forcible entry case was therefore proper. De la Cruz versus CA. Okay? De la Cruz was a lessee. She rented a house of the Reyes family for 4 decades. But the house was destroyed due to a fire, and the Reyeses deemed the lease terminated. But De La Cruz persisted in coming back and returning to the lot and occupied it. Okay? Now, the Reyeses tolerated the continued occupancy of the lot by petitioner. And then the Reyeses sold it to Tante. It was now Tante who filed an unlawful detainer suit. Your De La Cruz was saying that the unlawful detainer suit was not proper and that it should have been forcible entry because she just came back to enter upon the property. And because it should have been forcible entry, she is now saying that the action has already prescribed. Okay, what was the decision of the court? Is it forcible entry or unlawful detainer? The Supreme Court said it's unlawful detainer because possession by mere tolerance is a species of unlawful detainer. Remember that the De La Cruz's entry from the start was lawful. And then it turned unlawful due to the tolerance after the lease was terminated. Again, we said the main difference between the two, if it's forcible entry, then the entry from the very start is unlawful. Here, the entry was not unlawful from the start. If it's unlawful detainer, then the entry was lawful from the start and then it turned unlawful. And possession by mere tolerance, why do we say it's a species of unlawful detainer? Because we said in unlawful detainer, the possession has already been terminated and there is a contract expressed or implied from the very beginning. Okay? The Supreme Court further said in that case, in allowing several years to pass without requiring the occupant to vacate the premises nor filing an action to eject him, plaintiffs have acquiesced to defendant's possession and use of the premises. It has been held that a person who occupies the land of another at the latter's tolerance permission without any contract between them is necessarily bound by an implied promise that he will vacate upon demand, failing which a summary action for ejectment is the proper remedy against them. Okay? So what are the essential requisites of unlawful detainer? First, the fact of lease by virtue of a contract express or implied. That's precisely why your possession by mere tolerance can qualify under here because it says there express or implied. So if it's possession by mere tolerance, there is an implied contract that yes, you may stay there, but if we want you to vacate, then you must vacate upon demand. If you don't vacate upon demand, then an ejectment suit is proper. Second requisite, the expiration or termination of the possessor's right to hold possession. Third, withholding by the lessee of the possession of the land or building after expiration or termination of the right to possession. And fourth, and this is jurisdictional still, the demand letter upon the lessee, and there must be a demand to pay and vacate. Again, the demand must be to pay and vacate. And of course, the action must be filed within 1 year from the date of last demand received by the defendant. How about for forcible entry? First, the plaintiffs must allege their prior physical possession of the property. In other words, if you do not have prior physical possession of the property, then you cannot say that you have been dispossessed through forcible entry, because forcible entry means that you have been dispossessed through force, intimidation, strategy, threat, or stealth. Second, they must also assert that they were deprived of possession either by, as I've mentioned already, fists, force, intimidation, strategy, threat, or stealth. Third, it must also be filed within 1 year from the time the owners or legal possessors learned of their deprivation of physical possession of the land or building. That is for strategy or stealth. If it's force or intimidation or threat, then actual deprivation. The case of Ocampo. Okay. Here, so this is now an example of what I've said before as to which will prevail, which court will prevail on issues on ownership. Okay, here in the forcible entry case filed by Junicio against Mario built a piggery on a subject parcel of land. Junicio filed a case against Mario, saying that that was his property and Mario forcibly entered the property. Unfortunately for Junicio, the MTC ruled against him for having failed to prove prior physical possession. Because as what we've said, your number one requirement in a forcible entry case is you must prove prior physical possession. Now, in another case, after the death of Junicio, the heirs of Junicio filed a case against Mario. But this time, trying to recover ownership over the property. So the issue now was ownership. And the heirs of Junicio were able to prove that Junicio was the owner of the property. They were able to show evidences of ownership, monuments of title. And the court in that case ruled in favor of the heirs of Junicio. Here, your Mario, in that case for recovery of ownership, was saying that there's already res judicata, that previous court has already ruled that he has won and that he has a better right over the property. Here, the Supreme Court said that there is no res judicata. Why? Because in a forcible entry case, the issue is possession. While in the case filed by the heirs of Junicio, the issue was ownership. So, there are two different issues, two different causes of actions. That's not res judicata. And which will prevail? It's your action to recover ownership. So, since the heirs of Junicio won, in that case, then they will prevail. Okay. Now, let's talk about Accion Publiciana and Accion Reivindicatoria. Prescriptive period, it is within a period of 10 years. Otherwise, the real right of possession is lost. The issue here, okay, for Accion Publiciana, the issue is possession de facto or still material possession. For Accion Reivindicatoria, it is possession de jure or ownership. Okay? Hilario versus Salvador. Accion Reivindicatoria, according to the Supreme Court, is a suit which has for its object the recovery of possession over the real property as owner. It involves recovery of ownership and possession based on said ownership. While Accion Publiciana is one for the recovery of possession of the right to possess. So it's like an ejectment suit, but it's no longer summary in nature and you file it beyond the 1-year period. It is also referred to as an ejectment suit filed after the expiration of 1 year after the occurrence of the cause of action or from the unlawful withholding of possession of the realty. Bongato versus Malvar. The 1-year period within which to bring an action for forcible entry is generally counted from the date of actual entry to the land. However, as we have already mentioned, if it is through strategy or stealth, then the 1-year period is counted from the time the plaintiff learned about it. Now, in this case, the forcible entry case was filed by the respondents. It had already prescribed because they filed the ejectment suit on July 10, 1992, when admittedly they already knew that there was already entry as early as 1987. So there's already a lapse of more than 5 years from January 1987 to their filing on July 10, 1992. Now, the Supreme Court said, yes, you may be the owner of the land, but the forcible entry case is no longer available to you. But then again, that does not mean that you have no remedy. What you should have filed was an Accion Publiciana or an Accion Reivindicatoria case. Manlapas versus CA. An action for recovery of possession is totally distinct and different. This is what I've mentioned from an action for recovery of title or ownership. In fact, a judgment rendered in a case for recovery of possession is conclusive only on the question of possession and not that of ownership. It does not in any way bind the title or affect the ownership of the land or building.
So that ends our discussion on the important principles on property ownership. So I hope you learned something from this video and I'll see you in the next. So if you find this video helpful, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.